a scenario where you would lose a lot of property in a bankruptcy, you may be better off just allowing the home to go into a foreclosure, because if the lender in that 6-month statute of limitations doesn't pursue you, then you will have only lost your right to the property, and you'll have some difficulties getting a loan on another home for the next 2 to 3 years, but that would be the same case in a bankruptcy scenario. Okay, number 4 myth. Once I miss a payment or get a notice of default, I have to leave the property. Not true. And actually, like we talked about before with regard to keeping the insurance current, you're the legal property owner until the foreclosure sale is completed, the trustee's sale. So you should stay in the home, keep it occupied, and keep it safe until the trustee's sale is completed, a trustee's deed is recorded, which means you're no longer the legal owner of the property. If a kid gets into your house and falls into the pool because the house has been abandoned and the locks are undone and there's not any safety measures to prevent that from happening, the parents of that child, if that child is injured or unfortunately dies or drowns, they are not going to sue your bank, they're going to sue you. And that could cause some substantial problems for you, even if you haven't been living in the home and you've surrendered it. So it's very important that until you are no longer the legal owner of the property, that you remain in it, you keep it safe, and keep the insurance current. I know a lot of people, if they've missed payments, they feel bad about staying there, but it's really to your legal detriment to move out prematurely. And honestly, the banks would rather you stay. They don't want the property to be vacant either. It's less likely to be damaged or to have squatters come in, and they would much rather you stay in the property. So it's really the best scenario for everyone. Okay, myth number 3. A short sale is always better than a foreclosure. I think we've already covered that in the question that was asked earlier. But a short sale is not always better than a foreclosure. And vice versa, foreclosure is not always better than a short sale. If you can complete a short sale, get a deficiency waiver, and not have any tax consequences to the short sale is an excellent way to dispose of a property. However, if you cannot get the deficiency waiver and you only have a first deed of trust, you may want to consider doing a foreclosure. So we always encourage clients to not listen to what the neighbors say. Don't take into account what you've heard other people have done, because everyone's financial situation is different. Everyone's assets and complexities to their finances are different. And we don't give a cookie cutter answer, because until you look at your particular financial situation, you really don't know which option's best for you. And even then, there's, if you're relinquishing a home or you're relinquishing debt without satisfying it in full, there's always going to be a consequence. There's no golden path out of debt without some type of consequence. But the goal is to analyze the situation and find the least damaging consequence, or at least the consequence that has an amount of risk that you're willing to take on. The second myth, if my landlord isn't paying the mortgage, I don't have to pay rent. I think we already talked about that previously. And then the first myth is that the lender can't sue me once the foreclosure is completed, and that's not true either. The lender would have 6 months in which to start a deficiency judgment action against anyone that had defaulted and the foreclosure sale had been completed. Now, again, the second lien holder would have up to 6 years under a breach of contract. Okay, we have a couple more questions. Let's see. Where can you find out if your lender has satisfied the mediation you took them to? Okay, so this is about the foreclosure mediation program. All right, the foreclosure mediation program issues a certificate of completion when a mediation has been completed and both parties have satisfied their burdens under the rules. If the mediator's statement doesn't indicate that there were any deficiencies and the parties were unable to resolve the problem, then most likely the F&P program will issue a certificate of completion. The mediator does not make that decision. It's made by the program administrator or her delegated. She can delegate it to another person within the agency, but typically the administrator makes that decision as far as whether the certificate will issue. I'm a mediator for the program, and I have a lot of people that attend the mediation, and they ask me, when is the certificate going to issue? And honestly, we don't know. I've heard from some of the lenders' counsel that I see on a regular basis, that's who applies for the certificate, and they've said it can range anywhere from 2 to 3 weeks to 6 weeks to sometimes it's taken 6 months. When the program first started, it took a long time to get the certificate issued because they were doing everything by hand. Now the program has been switched over to a case management program that's electronic, so it's much faster, much more efficient, and it's definitely faster. So I think we're seeing more about way less than a 90-day turnaround to get your certificate of completion. Unfortunately, the F&P program does not have a database that the general public could access to see it, and they don't notify the homeowner if the certificate issues. So the way that you can find out if the certificate has issued is actually to go back to the recorder's page. If they have recorded a notice of sale, they usually simultaneously will record the certificate of completion. So a lot of times homeowners, the certificate's been issued, unfortunately, when the notice of the trustee sale is actually posted on the property. And when that occurs, you usually have about 20 to 30 days before the sale is scheduled to take place. And I know that that's really short notice for a lot of people, but that's the process that's in place right now. Another question. How do you know if your property documents are not phony, like shown on 60 Minutes? Okay. Yes, there are a lot of problems with the documentation. With regard to mediation specifically, as a mediator, I can't comment on the cases that I've worked on. As a borrower's counsel, I can tell you that in my wrongful foreclosure litigation cases, in my bankruptcy cases where we look at proof of claims and we look at the documentation that the lenders are providing, there are a lot of problems with those documents. The best way to know whether the documents being shown to you, whether you've asked your lender for them, you're participating in mediation, you're in bankruptcy, you're in litigation, ultimately an original note is like a check. It's a commercial instrument. It's a negotiable instrument, which means that in order for someone to cash in on the note, it has to be endorsed. It has to have a signature on it. Typically for a lender, it's going to say pay to the order of without recourse, and it's going to show the transfer of who's purchased the note. A lot of times when loans were coming out in the past decade, they almost exclusively were going into into pools, securities. Mortgage-backed securities became very popular. So unfortunately, most loans have been sold hundreds of times and traded in these packages and these mortgage pools. And that's where this entity called MERS, the Mortgage Electronic Recordation System, arose as a way for the lenders to be able to track the ownership or the ownership interest in the note, and then also be able to transfer without having to record. There's a lot of discussion and conflict amongst various legal experts as far as whether MERS in and of itself violates public policy as far as county recording statutes. Here in Nevada specifically, anytime a home or a loan or deed of trust is assigned, it should be recorded to show that chain of title. MERS was this, legal fiction that created an environment where you didn't have to record the assignments until or unless there was going to be a foreclosure, at which point it was kind of like, okay, who owns it now? Let's record that assignment. And so they avoided hundreds of thousands of dollars of recording fees by having this electronic system. The problem with the electronic system is no one kept track of these notes. So a lot of times when notes are produced, they're usually just copies that are taken out of the closing package because they go back to the original title company who closed the loan and get a copy that way. The original notes a lot of times can't be found, can't be identified. And the legal argument out there is that when the note has been negotiated and transferred to a new owner, but the deed of trust doesn't go with it, the two instruments are severed. And when the instruments are severed, then it creates a very debatable scenario of whether that bank still has an ownership interest in the physical property that the loan was originally taken out on. So when you look at these documents, the first thing I always look for on the original note is, are there endorsements? If there's an endorsement from Bank A to Bank B to Bank C, then most likely that's a legitimate document as long as there's those transfers. However, the allegations of robo-signing, and because a lot of times there's no dates or notaries that are included with these endorsements, it's hard to know whether that it was just done or if it was done simultaneously. And a lot of times you'll see persons signing these legal instruments. On one document, they're the vice president of Bank B, and then on the next document, they're the vice president of Bank C. And that's impossible. You cannot be a vice president of two different financial institutions. I'll skip the SEC lesson on that, but that's not possible. So there is a lot of fraudulent documents that has gone on with regard to the transfer of ownership with a lot of these loans. I think the litigation's been going on for several years in Florida, New York, and California, testing this theory of show me the note, which is kind of a catchphrase amongst attorneys to talk about the fact that a lot of these lenders don't really own the notes, can't really prove ownership, and can't really prove that they have the right to foreclose. Unfortunately, the state court and the federal court judges here in Nevada have not made any definitive rulings on cases like this that kind of gives us guidance as practitioners as far as whether they're going to force the lenders to produce these documents or how strict their interpretation with regard to recording statutes they're going to be. So Nevada on this topic is extremely young. We are very hopeful that the judges here will see that the banks have not properly securitized these notes and that there is a substantial lack of standing for foreclosure. But until we see case law coming down that is supportive of that, it's very hard for us to give those predictions to our clients as far as whether it's worth filing a lawsuit or not. Now in bankruptcy court, totally different story. Judge Regal actually made a determination almost 2 years ago that MERS, the Mortgage Electronic Recording System we talked about, didn't have standing to file a proof of claim. Now, it doesn't mean that MERS didn't have it. It just means that in that particular scenario where they were trying to get a lift stay, that Judge Regal did not